Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again, we continue with the same topic, which is the audit and auditor, right? So basically, if you see in the previous lectures of this chapter, right, what you find is that we were dealing with section 139, right, and its various subsections. Or if we see in the first lecture, right, we were discussing about the appointment of the auditor, right? So we saw the appointment of the auditor in the first AGM as per section 139 subsection 1, right? Where the auditor used to be appointed in the first AGM and then would continue for one term with ratification each year, right? And the term would consist of 5 years. But if it's a firm, the auditor could continue for two consecutive terms but should have been reappointed for the next term. And the individual, they go for the cooling period of 5 years again, right? And then we have seen the various procedures of how the audit committee and the board of directors are involved to suggest the name of the auditors to the members, right? So all these kind of things are something we have seen. But now understand one thing: if an auditor is first time appointed in the first AGM, right, then who takes care of the company before the AGM, right? So that does that mean that we do not have an auditor before the first AGM? The answer is no, right? So today we take up the next section and we deal with the appointment of the first auditor, right? And this is dealt by section 139 subsection 6 and subsection 7 for the government companies, right? So what does section 139 subsection 6 and 7 has to say is what we'll be seeing in today's lecture. Prepare for that? Right. So there are two cases, right? And both cases are independent with the two subsections. So case one is a case where a government company or a wholly owned, which are wholly owned by the central government, right? Or wholly owned by one or two of the state government, or held by central government as well as one or two of the state government, right? So these are the government companies. So in the case of government companies, right, you know, like auditors are also not the normal auditors. Those auditors are appointed by the CAG, Comptroller Auditor General of the country, right? So the CAG has a lot of power. So over here also, when you go ahead with the first auditor, right? So the first auditor will be appointed in the company by the CAG, right? So in case of all the government company, the first auditor will be appointed by CAG, and that will take place within 60 days of the registration of the company. Right, so if it's a government company and the company got registered on 1st of April, then we'll have to calculate 60 days from 1st of April, which will be somewhere close to 30th May, right? Or 29th May, somewhere like that, because April has 30 days. So it is 30th of May. So within those 2 months, but we'll not write 2 months in our answer because it is 60 days that has been specified in the law. So the Comptroller Auditor General has a time period of 60 days from the date of registration of the company to appoint an auditor. Right? So if the Comptroller Auditor General appoints an auditor, is well and good. But in the case where the CAG is not able to appoint an auditor, what do we do? Don't we have an auditor then? No. We will have an auditor, and that auditor will now be appointed by the Board of Directors. Right? So in the case of a government company, if the CAG is not able to appoint an auditor in the first 60 days, then in the next 30 days, that means the day that starts after the 60 days is over, right? In the next 30 days, the board of director will take the charge of appointing an auditor. So even till the 60th day, they'll wait whether or not the CAG is appointing. But if on the 60th day also the CAG is not able to appoint an auditor, then the entire power shifts to the board of directors. And then the power remains with the board of directors for half the tenure of CAG, that is 30 days. Right? So in 30 days, if they are able to appoint an auditor, we continue with the same auditor. But in case if they are not able to appoint an auditor in the next 30 days as well, then the matter shifts forward, right? Then the matter will shift to the members because they are the last resort. So the board of directors shall inform the members that listen, it's 90 days that has lapsed. 60 days with the CAG, 30 days with us, but we have not yet been able to appoint an auditor. So please suggest us what to do. Then the members will say, okay, you take your seat, right? Let us handle the situation. So the members will go ahead and appoint an auditor in the next 60 days at the extraordinary general meeting that they will hold. And in that meeting, they will appoint an auditor. So first, it's either done in the case of a CAG. CAG himself will appoint. In case the CAG is not able to appoint, we shift to the board. And in case even the board is not able to appoint, then in the worst scenario, we shift to the members. Right? So we hold an extraordinary general meeting for conducting the appointment of an auditor only. So this was section 139 subsection 7 actually, where it deals with the government company. Now if you move on to the next slide, it is the case 2. And the case 2 is basically about the normal companies, the other companies. So it is any other company. In any other company, the CAG will not play the role, right? I mean, CAG involvement, right? It takes place in a government company. So apart from government company, if there is any other company, right, then it directly goes from board and board to the member. There's no CAG involvement. But the only thing is the time period changes. For example, in the case of board, it's okay again that the first auditor will be appointed by the board within 30 days of registration of the company. See the change in the time period? The time period with the directors are the same, but if you see the time period of appointment of the auditor, that has shifted. In case of a government company, this time period was given for 60 days, right? In case of any other company, the time period that is given is only 30 days. That to do the board of directors. And in the similar fashion as in section 139 subsection 7, if the board is not able to appoint an auditor, right, then that auditor will be appointed by the member. But here the time period has changed. The members will appoint the auditor in 90 days time. So auditor shifts the case to the members, and members within 90 days will appoint the auditor at the extraordinary general meeting again. Getting the point? So over here there are just two layers, either the directors, the board of directors. If they are not able to do the same, then the members and nothing else. Right? And this entire condition is fulfilled in section 139 subsection 6. Okay? So, and understand the first auditor who is appointed, as you can see on the slide, will hold the office until the conclusion of the first AGM. Right? Why? Because in the first AGM, as per section 139 subsection 1, the subsequent auditor will be appointed and who will hold office for the tenure of 5 years if ratifications take place positively in the favor of the auditor. Getting the point? So when we talk about the rotation, doesn't mean that all the auditors will be equally the part of the rotation, that yes, when we come into the company, right, we will be there for 5 years if ratification goes well. Right? But again, there is a small difference that in case of the first auditor, this term of 5 years is not applicable. In case of the first auditor, the term is only till the expiry of the next AGM. And over here, the next AGM would obviously be the first AGM. Next, if we see, let's understand what a government company is, right? So we have been talking about the government company in section 139 subsection 7, right? So if you understand a government company, then a government company means any company in which not less than 51% of the paid up share capital is held either by the central government or by one or more state government, or partly by the central government and partly by one or more state government. Right? And the government company also includes a company which is subsidiary company of a government company. So all the government company plus the subsidiaries are all government companies. I hope it's clear with you. Right? Now, why is it important to identify a government company is again a question. Because only when you have identified whether it's a government company or normal company, that is the only position where you go ahead to apply section 139(6) or 7. That is where you choose. Right? Okay with the fact? So this is basically all about section 139(6) and 7 that we had to discuss. Right? But there are certain case studies that I would like to take up in the same lecture without sharing the questions and stuff. Just listen to me very carefully. Right? We are just sharing a situation. That suppose there was a government company, right, which was incorporated on any day, like somewhere on the 1st of April 2016, right? Then on the next month, 1st of May, right, 2016 again, the board of directors of the government company, they appoint somebody, Mr. X, as the first auditor. Do you think that situation is valid? Remember the days given to the director, right? It was 30 days. So I would say, chalo, okay, we'll presume that the board of directors, they have appointed the auditor in 30 days. So the appointment is correct, right? The first appointment of the auditor? The answer is no, right? Because the case they go to the director only in the case of section 139 subsection 6, which is the case of other companies. But in case of the government companies, the case first goes to the SAG. And then if the SAG is not able to perform the task, it is only then when the case is shifted to the directors of the company, right? So when you go ahead to write an answer of any such kind of a question, so first you will quote what section 136 has to say, right? That 136 subsection 6 says that, okay, in the case of a company, the first auditor will be appointed by the director within 30 days from the registration of the company. If they're not able to do the same, they'll pass on the case to the members and they will appoint an auditor within the next 90 days, right? But you again say that in case of section 139 subsection 7, the case is a little different. Over there, a CAG is involved who appoints an auditor in the next 60 days. And only if the CAG fails to appoint an auditor in the given stipulated period of time, it is only then when we move ahead with the others. And who are the others? The others are the directors and the members of the same company. Getting the point? This is the kind of case studies you will get, right? First, you will think that you are being tested on the time period or on the eligibility and stuff, but they are actually a way ahead, right? They see the entire picture. Okay, so this is how you go ahead with the answering. Now, there's one more case study that I think I should be discussing with you. Is, for example, take a case that there's a company, right? So that company whose shareholders, right? They include the insurance company, the bank, the state financial corporation, and stuff, right? So if I take an example, a banking company, a bank holds 12% or 15% of the share, right? Insurance company holds another 5% of the share, total 20, and Maharashtra State Corporation also holds somewhere around 15% of the share. It is 35, right? So when you see that a state corporation is holding the share, an insurance company is holding the share, a bank is holding the share and stuff, you may think that, okay, this is leading to the government companies where the states and all they have their shares, right? But if you look at the total stake, a government company is a government company only when 51% of the stakes are held by the central or the state government or a combination, right? But in this scenario, you do not find that percentage existing. If it does, yes, you will have to consider it in section 136, 139 subsection 7. Otherwise, in this scenario, you will only consider it in section 139 subsection 6 and nothing beyond that, right? But how do you go ahead to answer it? Whenever you answer, as I've also taught you the same in the previous lecture, right? Whenever you go ahead to answer anything, you first quote the section that all the provisions will be contained in section 139, and 139 has two subsections 6 and 7. So 6 talks about the other company, 7 talks about the government company. But then if you talk about what a government company is, right, then you go to the definition, and definition is section 2 subsection 45 of the Companies Act 2013. And in the definition you find that the government company is a company that is fully owned by central government or fully owned by one or more state government, or partly by central and partly by state, right? Or it's not, when I say owned, it is that the majority shares are with them. More than 51% of the shares are with them. And the other 51 is either one individual or 10 individual or 40 individual, they don't care. Getting the point? So this is all about section 139 subsection 6 and 7 about how do we appoint the first auditor. Because only after the first auditor is appointed, that auditor resigns in the AGM and then the subsequent auditor is appointed for the terms. Right now, an auditor is just appointed to take care of the scenarios around. And then the auditor will be appointed to look into the things in entirety and continue over the period, right? 1, 2, 3, 4, 5 years as the ratification goes successful. Okay, so that is all about section 139 subsection 6 and 7, right? In the next lecture, we'll go ahead to understand a little more about a government company or the subsequent appointment in the other companies, right? So I'll see you there. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.